My name is Stephanie Spears, and I'm Counsel of Program Development here at the Law Society. Can everyone hear me okay at the back? Okay. It's my pleasure to welcome you today to our first ever drafting program, Advanced Drafting for Lawyers. I have a couple of announcements before I make the introductions. First of all, if you have a cell phone, kindly turn it off or set it on vibrate. Secondly, we do include in the materials a gray course evaluation form. It's just following your schedule of events. If you could please fill that out prior to leaving today, and we'll have a drop box on the registration table. That would be a great assistance to us, as we do rely on those when we're planning future programs, and as it's a first-time program, we would really appreciate your feedback. Next, I'd like to tell you that for the morning anyway, we are recording this session, and it will be provided to lawyers across Ontario on videotape, so your image or voice may be captured on video. Also, for the workshops in the afternoon, there is a corkboard outside in the coffee area with your room location listed there in your name. When you are traveling up and down to the different floors, if you use the stairwells, you will get locked inside because you need a code, a pass code to get off onto the floor. If that happens by accident, you can go down to the basement and come back out and take the elevator. But please use the elevators. They will not be pass restricted, so you'll be able to access all the floors by the elevators. Finally, for those in the employment law workshop, there are additional handouts. If you are someone who is not in the employment law workshop, but you would like those additional handouts, please make sure that you come back on the afternoon break to the registration desk and you can pick those up. Everyone has all the materials for all the workshops in their binder, so that's an additional material. Finally, I would like to thank our chair, Philip Knight, and all our faculty for their hard work and creativity in devising this program. Phil Knight resides with his wife and one remaining child, he's got 3 that have left home, in Vancouver, British Columbia. He teaches drafting at the University of British Columbia for the past 6 years. Mr. Knight acts as a legal advisor in the fields of public law, constitution, and governance for various First Nations groups, corporate sector clients, and domestic and foreign governments. Certainly in the last 6 or 8 months as I've been working with him on this project, I've had to contact him overseas and different parts of Africa, and he's often called from the remote north of Canada. So he certainly has an interesting and extensive practice that leads him all over the country and outside the country. Phil is one of noted in Canada for his work in plain language. He is the past executive director of the Plain Language Institute of British Columbia and the former director of the BC Government Plain Language Office. I believe that you're in for a wonderful morning, and prior to turning the podium over to Phil, I will introduce to you also Mr. Paul Herricks, as they will be the first panel to go up. Mr. Herricks is a partner in the law office of Gowling, LaFleur Henderson, with a transaction-based practice in the areas of mergers and acquisitions. He practices in corporate finance, project development, and finance and energy law. I will let you look at his biography for the full information, but I would like to mention that he does a wide variety of lecturing at CLE programs like this and other seminars. He is a member of the corporate law subcommittee of the OBA and a contributing editor to the Canadian Business Financing Handbook. So on that note, I am very pleased to welcome Phil Knight and, of course, Paul Herricks, and turn the podium over to him. Thank you.
Thank you, Stephanie, and good morning to all of you. You'll see that some of us have dared to venture across the Rockies and into the unsafe territory of Toronto, and thank you for your warm welcome and your good health. Although I noticed last night when we were at dinner that the streets were closed, sirens blared, and long motorcades of people in black cars came down the street, and I thought they didn't give that same treatment to Halton and I think Toronto could sort of be a little more Catholic in its extending official welcomes to people who come into town to prove there's nothing wrong with the health. This morning we're going to talk all day. We're going to talk about drafting. We're going to talk about drafting a variety of different kinds of documents and different kinds of legal instruments. In this morning's sessions, we want to talk about drafting in a very broad and general way. This afternoon, we're going to talk about it in more particular, with more particular focus, depending on the interests that you've expressed in the workshops you've selected. My observation is that no matter what kind of work you do, no matter what kind of clients you have, clients come to us as lawyers and they ask us for certain things. Sometimes it's a client who wants a will, sometimes it's a client who is separating, sometimes it's we represent a trade union in negotiating collective agreements and drafting them. And whatever the instructions are that they give us, they all have one thing in common, and that is that what they really want from us is certainty. They want certainty not just for today, they want certainty in the future. They want, in short, for us to freeze present intention onto a page so that it will guarantee that in future circumstances, future unpredictable circumstances, future circumstances that the client herself can't even imagine at the moment, her present intentions will be given effect to. And we actually have the audacity to purport to sell that kind of certainty to people. I think we need to pause sometimes and ask ourselves on what basis we do that. First of all, it presupposes something that I think is mostly lacking in the clients I deal with, and that is that there is in fact a singularity in their intent in the first place. But even if a client has a singular sort of intent that they want me to freeze in the present and project into the future, to do so successfully with certainty presupposes that there will be uniformity of agreement about the use of symbols, word symbols combined into sentences, organized into a text. There will be agreement about those symbols, and there will be agreement about the meaning to be taken from those symbols, and that agreement will be universal across all the people who read the document the day it's drafted and all the people who read the document subsequently. It also presupposes, it seems to me, that there will be a pause in the social evolution of both law and language for the time that the document governs. And finally, it seems to me that it presupposes that there will be a willingness on my client's part in the future, when circumstances arise, my client will be willing on that day to set aside her personal advantage, as she calculates it then, in favor of the perceptions that she had on the day she gave instructions. In 20 years of drafting legal documents and practicing law, I have to tell you that I have seen nothing to suggest to me that any one of those presuppositions is valid. And everything in my experience suggests to me that every one of those presuppositions is invalid. So indeed, how do we sell certainty? How do we ground certainty? Well, historically, and I'm going back now to a mythical point, I suppose, in time, but we can project our own experience back to legal documents we've seen. But I'm going to say, at least in the 19th century and the early 20th century, the doctrine of law I would characterize as being formalistic in its thinking about legal language and legal documents. There was a high degree of belief in the certainty of words, certainly in the certainty of those words that had been judicially interpreted and those precedents that had been judicially interpreted. And so many of us were taught, indeed, that certain things should just be used in the way they are because their meaning is certain. A judge once said that ABC in that context means X, Y, Z. And so we can always go on using ABC if what we want to do is convey X, Y, Z. And many of us were taught to believe in that notion, in that faith, because it was little more than a faith. But it gave rise to a kind of writing that became incredibly difficult for people not trained in the law to understand. And in the middle part of the last century, and with growing stridency in the decades that followed the 50s and 60s and 70s, there began to be a claim that legal language was deliberately made difficult, that this pursuit for certainty that had led to a high degree of formalism, in fact, was all a device, if not a conspiracy, to shut out others and allow only an elite group of people to participate in the exercise of lawmaking and law interpretation, and therefore in the governance of many, many details of a society. And the notion arose that if you could get rid of the overburden of legal language, of legalese, whatever that might mean, and to just state things simply, that the law would be certain. Just make it plain became the rallying cry for many people about legal and indeed government documents. There was a belief, a faith, that if we got rid of formalism in legal language and substituted it for populism, we would have certainty. In short, the language of the common people would be the language of the law, and since the language of the common people would be widely understood, the law would be widely understood and therefore would be certain. Then, of course, people began asking the question, well, that's very interesting, but what is the language of the common people, and what does that mean? And what does it mean to write a document so that it's plain? And we began to get answers. And now there are groaning bookshelves, volumes of answers of books on plain language for lawyers and writing in plain language and writing in simple language, and some of them have very interesting ideas. And if you begin to immerse yourself in them, you find that the ideas tend to repeat, and there is almost a catechism about the ideas of how to make language simple. And the catechism is repeated so often by some people that it becomes its own new formalism. If you keep your sentences down to 25 words or fewer, always use the active voice, never, never, never use shall, and banish hereby, organize your sentences in a subject, verb, object way, and I think I've almost got my catechism complete. Your meaning will be plain. Really? It might well be plain. And therefore it will be certain. Oh. What are you saying? It's impossible to convey an ambiguous statement in simple words? I think not. On an airplane coming into Toronto, there is a notice board where they store the tea trolleys, and it says all trolleys must be stored during takeoff. Oh, all carts or no carts, pardon me, all carts or no carts must be stored during takeoff, landing, and turbulence. And I thought, well, that's a short sentence and it's fairly clear and the words are all simple, but what do they do on a no-cart day? Where do they store the trolleys, and how come in all my travels I've never been on a plane on a no-cart day? To know the answer to that, you can come up with a fairly ambiguous, vague, and quite meaningless statement following all the rules of plain language. But there is a belief, and it is widely held and advocated within our profession, that we've moved from formalism, we've moved beyond populism, we are now at what I call populist formalism. And our writing will be certain. I think that we're not much better off with the rules of populist formalism than we were with the rules of traditional formalism in legal writing. We might construct nicer sentences, and indeed more people might understand them. But if they are uncertain, they are uncertain. If they're wrong compared to my client's intent, they're just more plainly wrong. We'll talk more about the issues of plain language in the panel that follows. And in the case comment that I prepared today, I look at one of the most recent high judicial statements in this country on the subject of language and how we might view it and how we ought to draft. And I have to say that while the fact situation in the case is fairly narrowly applied, I mean, it arose out of very particular notice requirements under the Ontario Insurance Act, and therefore, strictly speaking, applies only in that context. We cannot ignore the fact that it is a statement of the Supreme Court of Canada, it is a near unanimous decision of that court, and that it speaks in language that itself is considerably broader than the issues raised for the court by the fact situation. And so I look at that and I say, what is it that the Supreme Court is saying to us about language? My first observation is it's saying something that I find very encouraging. And that is it's saying it's time for us to take language seriously. I want to make this observation. We cannot do what we do without language. There is no law without language. We have no other tool. None. Everything we do is either written or oral. It might seem passing strange then that there weren't very many classes in law school on language, but we're trying to fix that. The Supreme Court said, it seems to me, it's time to take language seriously. It's time to look seriously at what is required if a regulation under the Insurance Act says you have to give notice, the clock and the limitation clock doesn't start running until you have given notice to the insured person that she is no longer entitled to benefits. The second thing I will say in a very positive way about the decision of the court was that they found a middle ground between two very undesirable alternatives presented to them by counsel for the opposing sides. Counsel for Ms. Smith, in this case, essentially said the insurance company has an obligation to provide all of the procedural information set out in the Insurance Act, but they have to do it in language that an unsophisticated person can understand. Now, quite apart from issues of, well, what's wrong with the statute? Why can't it do that? Why can't we just give her the statute? The court said, no, you don't actually have to give all of the information, but faced with the opposing view of, well, then we can just piece out the information one step at a time, the court said, no, that's not acceptable either. And rather said you have to provide sufficient information that the in this case, insured, has a framework for making the essential decisions she has to make to guide the process in consultation with her legal advisor. And I think that the court has done us a great service in articulating that particular rule. It is a recognition that a statement doesn't stand by itself. The proposition advanced on behalf of the insurer was to say, well, if we give her one piece of information, she can decide what to do, and then if we give her the next piece of information, once she's chosen branch B, we'll give her the relevant branch B information. Well, the problem is that none of those pieces of information exists in isolation. And we can't make decisions based on just one piece of information. We make them based on a context. And essentially what the court has said is when we're required to give this kind of information to people under statutes, at a minimum, we have to frame the context. And in saying that, it seems to me they have said, they have endorsed the notion that language is contextual. And that is in keeping with best principles and best thinking about language itself. But let me now say what I find troubling about the court's decision. It got to this issue, what information do we have to give, because it universally, all the judges involved, accepted at face value an opening proposition, and that is that all insured in Ontario are unsophisticated. Now, I don't live in Ontario and I'm not an insured here, so I can't judge that myself, but I suspect that there's a good possibility that Ms. Smith herself might have worked for an insurance company. There are a lot of them in this province. I don't know whether she did. There's nothing in the facts to tell us anything about her. And therein, it seems to me, we have a problem. Because it was the assumption that all insureds must be unsophisticated that led to the central problem in the case, which is how do you communicate complex information to unsophisticated people? Do you do it one piece at a time, just in time? Or do you do it by giving them the whole package and making them sort it out for themselves? Or do you do it now, as the court has suggested, by providing a minimal amount to enable a person to come up with a context? But what if the people aren't all unsophisticated? If they're not all unsophisticated, you don't actually have to ask the question, or at least you don't have to ask the question in that way. And in adopting what I call a universalist notion of audience, never mind a universally unsophisticated notion of an audience, the court has not only, it seems to me, come up with a rather difficult concept for us as drafters to address. I mean, what does it mean to be unsophisticated? How unsophisticated is unsophisticated? Are we talking an illiterate readership? Are we allowed to assume certain levels of education? Those issues aren't addressed in this notion of the unsophisticated reader. But the court has also turned its back on its own previous doctrines in other areas of the law. Now Chief Justice McLachlin, Madam Justice McLachlin as she then was in 1991, writing in the context of criminal law, said of an accused, the trial in this case was a murder trial, turned on the issue of whether or not he had properly waived his right to counsel. And there was evidence that he was in fact substandard intelligence. And she said, it isn't a question of whether the police recited perfectly a formula that must determine. It is what the accused could reasonably be said to have understood from the words that were directed to him. In short, it is subjective. In short, we look at the person who has received the message and we say, what could this person reasonably be said to have understood? And that is, in fact, the same doctrine that applies across the country when we examine, did a plaintiff, in fact, waive liability in a high-risk situation? What could this plaintiff be reasonably said to have understood from the documents that were put in front of them and anything that was said when those documents were put in front of him or her? We look at the individual plaintiff. We ask, what are their skills with language? What is their familiarity with the risky activity? What were the words used on the document itself? And was there a real opportunity for that plaintiff, given that plaintiff's ability with language, to understand those words? And now we take a 180-degree turn in the context of insurance law and say, let's not look at Ms. Smith at all. Let's not consider her abilities, her knowledge as an insured person. Heavens, she might be a nuclear physicist. She might even know what derivatives are, for heaven's sakes. But we just write her off as unsophisticated, and on the basis of that say she can't understand words in relatively simple sentences, and therefore the insurer has to go farther. I find that a troubling and disturbing evolution in the law, and it creates great uncertainty for us. I suppose in one sense it creates a level of certainty. We have a standard and it applies universally. We're not quite sure what the standard means, but it applies universally. Let me say as well that I take a further troubled view of not just the audience standard that the court articulated, this notion of a universalist, unsophisticated person, but in fact the style standard the court articulated. The court said that the language used must be straightforward and clear. And in the majority decision, there is in fact a very negative indication of what does not constitute straightforward and clear. I mean, the court didn't turn its mind to say what would constitute straightforward and clear, and so we are left with some considerable uncertainty, but we are given a negative indication. We have these words from Justice Gonthier. There is some doubt in my mind as to whether the notice given by the respondent in this case would even be considered a refusal, in a non-technical sense, absent the letter sent to the appellant's solicitor. There's an equivocal sense of indeterminacy in the decision of the insurer, giving the reader the impression that the insurer may very well change its stance if it's contracted for a discussion of the matter. The letter to the solicitor in this case removes any doubt by clearly stating, quote, Ms. Smith is no longer entitled to income replacement benefits. The trouble with his commentary here is that the letter to Ms. Smith said, quote, you are no longer entitled to income replacement benefits. Now, Justice Gonthier clearly says the words addressed to Ms. Smith, you are no longer entitled to income replacement benefits, are not clear. But the very same words addressed to her lawyer are clear. He doesn't comment on that. In fact, he didn't comment at all on the statement that was addressed to her and the comparison between the two. So we're left with this troubling thing. The same words addressed to legal counsel meet the test, but when addressed to the insured, don't. But what possible words was the insurer supposed to use? I mean, I must tell you that I'm at a loss to know how the insurer was supposed to communicate this message. And as you'll see in my paper, I did some research on that to see whether or not these words really are understood, or at least whether they're very frequently used in Toronto. And you'll see that on average, every word in the sentence was used at least on an average 7.5 times a day in the Toronto Sun. Make no comments about the readership of the Toronto Sun, but finally, let me say that there is there's a parenthetical discussion in the majority's decision that I find indeed at best unfortunate and at worst somewhat frightening. And this is a discussion about the use of prescribed or approved forms. The defense of the insurer that, look, the form we used was approved by the Ontario Insurance Commissioner's office. And the court said, well, that's interesting, but not relevant, because your obligation is to communicate the information that the statute requires you to communicate. And that it is not enough. The industry practice of using prescribed or approved forms to meet a statutory obligation is not sufficient. So said the Supreme Court. Except that the legislature not only said it is sufficient, they in fact required it. So here is where we are, caught between a legislative obligation to use a prescribed or approved form and a judicial doctrine that says you have to do something else. One can only hope that the court quickly clarifies for all of us how we are supposed to weave our way between those two positions. The court seemed to suggest, and in my mind rather cheerfully and cheerily suggest, that it's okay. I mean, a prescribed form can have things added to it. You can have a notion, as I say in the paper, of a prescribed form plus. But with the greatest respect, a prescribed form that's had something added to it is no longer the form as prescribed. And that constitutes using something that the statute expressly forbids. I'm troubled by this at more than one level. I mean, the first question is that the legislature gave to the Commissioner of Insurance the responsibility of determining what should and shouldn't go in the form. It did not give that responsibility to the court. And it seems to me, absent an action by somebody saying that the Commissioner of Insurance had failed in its statutory responsibility with respect to the form, the court really doesn't have jurisdiction to look behind the form and ask whether or not it's proper. But nevertheless, we have this, and one can say, well, this is obiter in this case, and maybe it is. Let's hope it is, but more to the point, we desperately need some certainty. There are literally, as you all know, thousands of prescribed and approved forms that we're required to use. And if in fact, as the court suggested, there is a further obligation on us to use not only the form, but in fact to meet some vague test of completeness, go behind the form, I think we need some clarification on what exactly it's going to take to meet that, or our world has become considerably less certain indeed. Let me conclude by, in fact, I'm going to conclude just by handing over to Paul because I've taken more than my share of the time. But the rest of my concluding comments are in the paper.
Thanks very much, Phil. As a commercial lawyer, I must confess that when Phil first suggested that we would be using a case that, at least on the surface, deals primarily with limitation periods in insurance claims, I was a bit skeptical about the relevance of it for a session on drafting. But as soon as I read the case, and particularly when I read Phil's comment on the case, I realized that there are pretty significant lessons in this case, I think, for anybody who's involved in, such as myself, in drafting commercial documents. One of the most intriguing aspects of the case, in fact, I think, is why it ended up in front of the Supreme Court of Canada at all. If you look at it, the insured lost at the trial level, lost at the Court of Appeal, and there must have been something in this case that grabbed the attention of the Supreme Court of Canada and was sufficiently compelling to them. They wanted to convey a message, I think it's fair to say, to lawyers at large and commercial lawyers and lawyers drafting a wide array of legal documents, and they've certainly conveyed that message. Whether it's a clear message or not, I think is very much still at issue. There are a number of aspects of the case, and I'll talk a bit about it before I move on to, I think, a more general discussion about some of the aspects of commercial drafting that I wanted to address before we break in this panel. But one of the interesting parts of the case, and really part of it that doesn't really get dealt with in much detail, is the implicit judgment throughout that the legislation itself is by definition unclear. None of the judges who sat on the case at any level thought that would ever be sufficient simply to provide the insured, in this case, with a verbatim recitation of what the statutory and regulatory provisions actually say. It was always implicit that needed some legal intervention, some lawyerly intervention, in order to make what was clearly unintelligible to the average reader intelligible. And the court differed all the way along the line on exactly how that test or that task should be met. But it's interesting that there was never any real criticism throughout the judgments directed towards the legislation itself. And in fact, I think it's fair to say, if you look at it, the legislation and the regulations could have been a whole lot clearer, and if they had been clearer, they probably never would have got to court in the first place. So that, I think, is a lesson that maybe Ralph Armstrong can pick up and talk a bit about later on in the morning when we talk a bit about drafting and from a legislative drafting perspective. The other, I think, aspect of it that's interesting is that in this particular case, the court spends a good deal of time talking about the audience to which the particular document, in this case the notices, are to be addressed, and focused almost entirely on the fact that, that the insured, Ms. Smith, was the recipient of those notices. But of course, as Phil alluded to in his remarks, to the knowledge of the insurance company, the insured was represented by counsel. So it really begs the question as to what level of sophistication one has to assume where, to the knowledge of the person giving the notice, the recipient of that notice is represented by legal counsel. And Phil rightly points out that the words that are used in the two notices are virtually the same. The other interesting thing to me about the notice is that you talk about plain English. The notice could not be plainer in terms of its English. It was clearly drafted by somebody with due regard to all of the conventional rules of plain English drafting. The notice was short. It was in simple words, I think no more than 2 or 3 syllables. The sentences were 5 or 10 words in length. I think what the court focused on was not so much whether the language was plain or clear, but whether it was sufficiently complete. I practice a bit in the area of securities law, and I think if you practice in securities law, you'll be familiar with the concept of full, true, and plain disclosure. I think what we had here was disclosure that may have been plain and it may have been true, but it wasn't full. And I think when they talk about whether the notice was sufficiently clear or not, they're really talking about the fulsomeness or the completeness of the notice, rather than whether it was in fact well drafted from a sort of a conventional plain English analysis. Let me move on to talk a bit about, I guess, the world in which I practice, and that is a world in which we are under increasing pressure from clients to keep our fees low, increasing pressure to get deals done quickly, to turn documents around quickly. We are in a world in which we all have access to a vast array of precedent documents that we rely upon implicitly, and I'm not going to talk today very much about the use of precedents, but that's a whole other area and challenge for lawyers in terms of legal drafting. We're also in a world in which the advent of word processing technology and email allow people to swap documents, trade documents, and work on documents really in a collaborative, to put it in its best light, a collaborative way, but also in a way in which the source of any particular clause or provision in an agreement, by the time the agreement is drafted, gets muddied. I've been around long enough to remember the days in which a lawyer or a law firm would take control of a particular document in the context of a commercial transaction at the beginning, and that lawyer or law firm would basically have control over the document from start to finish. One of the things that meant was that the document would typically speak with a single voice, that clauses, although concepts may be brought in from different law firms and different clients in the context of a negotiation, at least the draftsperson remained largely the same. One of the problems I found with email in the last, I guess, 4 or 5 years since email transmission of documents has become so prevalent in commercial negotiations is that everybody gets their kick at the cat. Lawyers, non-lawyers. It's not at all unusual to end up with 5 or 6 different markups of the same document, all of which are black-lined and all of which are sent back to the original lawyer, who then has to piece together what may appear to be, and very often are, very different approaches to drafting. And I think that's a real challenge for lawyers, and one of the things that I think leads, I think, very often to a document that doesn't look as well put together, perhaps, as it might have been the case 10 or 20 years ago before the advent of technology allowed that to happen. In my paper, I identify a number of conventions, and I won't really go through a lot of these this morning. One of the areas I did want to talk a bit about, since the topic of this panel is really drafting for certainty in an uncertain world, is the fact that in commercial practice, very often we are intentionally uncertain or intentionally ambiguous in some of the documents that we draft. And I recite a few examples in my paper. One of the first things that you typically do as a commercial lawyer when you're reviewing somebody else's handiwork, a first draft of a document, is to go through it and insert the word material, or the words in all material respects, or the words in in the reasonable opinion of, everywhere where you think you can get away with it in order to qualify what would otherwise be a fairly harsh representation or harsh covenant. Those are uncertain words. I mean, by definition, the concept of materiality, the concept of what constitutes reasonable, the concept of what constitutes good faith, for example, those are all concepts that are very much in the eye of the beholder. There is obviously some judicial gloss on some of those contexts, or those words in certain contexts. But for anyone in this room who thinks that they're spending a lot of their time fine-tuning a document to make it more certain, I think it's probably fair to say that the first draft of a document is often a much more certain document from a conventional standpoint than the last draft, the draft that is riddled with concepts of materiality and reasonableness. I think that's something you just have to bear in mind as you work your way through documents. I also want to talk a bit about some drafting techniques, and one of the things I've observed, I guess, over the years is how certain drafting conventions do arise in certain jurisdictions. It's remarkably easy, in my experience, to tell just by looking at the surface of it, a document that is drafted by a Canadian lawyer as opposed to an American lawyer as opposed to a British lawyer. They all display certain rather interesting and unique national characteristics, and I think if somebody hasn't done this already, Phil, somebody someday should probably do some sort of a legal/sociological study of how different lawyers in different jurisdictions draft documents. In my experience, Canadian lawyers are actually amongst the best in the world in terms of how they set up and draft their legal documents. I'm always amazed when I get documents from many U.S. counsel as to how un-user-friendly, if I can use that expression, they are. They tend to, in my experience, use large chunks of text. They don't use what we would regard as fairly, I think, conventional and helpful concepts of paragraph sculpting, where you basically show the relationship between clauses by consecutively indenting them and leaving spaces between clauses. And it's more than simply making the document one that users and readers, particularly non-legal readers, can read easily. Some of those concepts of paragraph sculpting, I think, have real significance in terms of how documents are drafted. I'm sure you've all had the experience, I know I have, where when you don't have a document that is drafted that way, trying to determine the interrelationship between various clauses, whether particular words are intended to modify clause A and B or just clause B, unless you follow the concepts of paragraph sculpting to some degree, some of that can be difficult to follow. Also, a couple other sort of I always use these sessions as a way, in some senses, of getting some of my pet peeves off my chest, but one of them has to do with the way in which lawyers deal with concepts of, or the manner in which they deal with definition sections of agreements. And I think what I may do is talk a bit about this, and then I think we have about 2 or 3 more minutes. Phil, do you want to leave time for questions at the end, or?
We're going to do questions at the end of the morning.
The end of the morning? Okay, so I'll carry on till my allotted time. In my paper, I spent a bit of time talking about definitions, and any document, in my judgment, of more than 5 or 6 pages that uses definitions should aggregate those definitions and put them in a single section of the agreement. We are all familiar with that concept because most statutes, in fact, are set up that way. But definitions, in my judgment, should be sections that deal solely with the definition or the establishment of defined terms. One of the things I continually try to ensure that the more junior people in our firm avoid is to try to use the definition section as a means of actually establishing covenants or representations and warranties. In my paper, I use the fairly simple example, which you often see, where, for example, in a business purchase agreement, you're defining the term purchased assets, and the definition reads something like purchased assets means all of the assets used in connection with the business, a true and complete list of which is attached hereto as Schedule A. To me, that is a covenant for the most part, not a definition. The fact that the true and complete list, or that the list that is attached to the agreement as Schedule A is supposed to be the true and complete list, is something that really should be in the covenant section of the agreement rather than in the definition section. I also wanted to say a few words, I guess, about some of the other sort of concepts, I guess, around definitions. One of the other ones that I guess concerns me a bit, and it's a drafting point really, is the way in which very often we use the word includes rather than means. In my judgment, at least, a definition should always use the defining verb means rather than includes. One of the things that I think is uncertain very often is a definition such as the one that says directors includes shareholders, for example, acting pursuant to unanimous shareholder declaration or unanimous shareholder resolution. Very much begs the question of what it excludes and what it might include. Another thing I wanted to just sort of talk about, and this is coming up, I guess, more and more in my practice at least, is the use of formulas and the challenges associated with trying to translate what are really mathematical concepts into our stock and trade, which is words in the English language. I do a fair amount of work in the area of derivatives, and I do a fair amount of work in the area of securitizations, but this also comes up, I think, very often in loan agreements. It comes up in share purchase agreements, shareholder agreements, any sort of an agreement where you're trying to convey a mathematical concept or formula and put it into writing. And one of the things that I find lawyers are particularly bad at, and maybe it's because most of them, such as myself, didn't take mathematics past high school, is attempting to take mathematical formulae and put them into writing. My urging to you, I guess, is to make sure that when you are asked to provide those kinds of mathematical concepts, A, you work very closely with whoever it is that's giving you your instructions, because it's typically their formula or their concept you're working with. But B, feel free to use real-life examples. I just worked on an agreement recently where we had, I guess, about a half a dozen or so fairly complicated mathematical formulae, and we all concluded that the best way to convey how we intended them to work from a legal perspective was to actually attach a series of examples as one of the appendices to the document. I think traditionally commercial lawyers were discouraged from using examples. I think the conventional wisdom was that the words of the formula themselves should be more than sufficient, but I think increasingly people are using mathematical formulae, and Phil talked about how our stock and trade really is words, but in this case it's words coupled with some mathematical concepts as well. And I think it's about 5 to 10, so perhaps I will leave it at that for the moment. I deal with a number of other issues in my paper, and I'm certainly happy to respond to any questions at the end of the morning. Thanks.
Thank you, Paul, and I think that just looking through your paper, some of the suggestions and things you have are probably would segue nicely into the next part of this program, which is the panel on plain language. I think, Stephanie, are you going to do introductions for us? Thank you.
Thank you both very much for that presentation.
Thank you.
It's my pleasure to introduce to you now the members of the panelists and our moderator for our plain language panel. First of all, I'd like to introduce Erica Abner, who will be moderating today. Erica designs and teaches programs on legal writing and drafting. She has over 15 years of teaching experience at all levels of education, legal education, including as an adjunct professor of law at Osgoode. She's a faculty member of the bar admission course and as director of continuing legal education at McCarthy's. She's currently a PhD candidate at OISE in legal education, where she is concentrating on researching mentoring in law firms. Next to Ms. Abner is Hugh Lawrence. Hugh is the Director of Knowledge Management at Goodman's in Toronto, where he is in charge of the development of firm precedents and the firm's intranet. He graduated from Osgoode Hall in 1982 as a silver medalist, and I'd like to also mention that he is Director of Corporate Services at Goodman's, and he teaches a university course on management information systems and lectures regularly to lawyers on law office technology and legal writing. next to you is Ralph Armstrong. Ralph was called to the bar in 1985. He was previously the director of the Legislative Division of the Nunavut Department of Justice. He currently works with the Department of, with the Office of Legislative Counsel as a legislative drafter. And he has also worked with the governments of Nunavut and Saskatchewan, as previously mentioned. He also maintained a private practice as a legislative drafter previously. And finally, I'd also like, oh, you've already, that's it? You've already had an introduction to Phil, and on that note, I just introduce our panel. Thank you. Oh. Just going to take a moment here to get this focused. So, perfect. Okay. We on?
Stephanie, do you mind staying up to move it? I made it big, thinking that we would be on one of the ordinary overheads.
An ordinary overhead, right.
While Stephanie's putting up the overhead, I'll just start off with some introductory remarks to launch the panel on plain language. When I was asked to participate in the program, I actually started out by musing on the difference between basic legal drafting, which is what I teach to the law students, and advanced legal drafting, and really came up with to the conclusion that there really isn't much of a difference. Both basic and advanced legal drafting rest on the same foundation of technical skills, doctrinal understanding, attention to audience, and the ability to assess risk and forecast events. So what is advanced legal drafting? I'm going to suggest to you that advanced legal drafting is really advanced problem solving. And that as we move from law students, articling students, young associates, more senior associates, partners, what we're doing is actually solving more and more complex problems within transactions. So what we're really looking at in this panel is how plain language can help us to solve these complex problems. And I wanted to start out with a bit of a definition or a description of what plain language is, and I came up with this 2-paragraph excerpt from an address by Robert Eagleson in 1988. And it's up here, so if I give you a minute just to have a look at it and go through it, and point out to you 3 aspects of it, this description, that are going to frame, I think, the panel for the next few minutes. Robert Eagleson, by the way, is considered one of the deans of the plain legal language movement. He's an Australian lawyer, has been very active in the field for a number of years. So let me point out 3 aspects that Robert Eagleson refers to in this that will frame the panel. The first is the importance of audience. The second is the importance of organization. And the third is the importance, as Phil has noted for us previously, of not conceiving of plain language or even legal language as a series of rigid formulas. And so, having said that, I'm going to turn this over to Ralph to start us out on the importance of audience.
Thank you. As I sat down to write my paper on the subject of plain language, it had the interesting effect for me, as writing often does, of making clear in my own mind what I thought about plain language. And the first thing that hit me was plain to who? Simple-minded, but when we're talking plain language, I think we have to frame our issues plainly. A bill speaks to an audience, granted. Is it trying to make a statement that the government is in control of a situation, that we are taking firm, decisive action to deal with an immediate problem? In that case, it may be read by journalists, by enforcement personnel, police officers, a wide range of people, all of whom are approaching it from their own levels of education, of understanding, of interest, and who are being spoken to on instructions. I was raised in a school of legislative drafting that said preambles are bad, purpose sections are bad. Just get in there and let the document speak for itself. Quite often, in the course of my drafting career, I've been told we need a preamble, we need a purpose section. These legal issues that you're telling me about, that there might be a conflict between the provisions of the Act and your purpose section, do not concern us. We want a statement out there, right front. We are acting. So, you're working for a client. We're always working for a client, private practice, public practice. You work with a purpose section or a preamble that sells, that makes that plain language statement, and you work from that the later provisions, the hard law sections that we feel more comfortable with, are playing to the hard law audience and work in accordance with that purpose section. You try to make it plain to the many audiences that you're reading. It doesn't always apply. You have to think through in each project what's going on. A vast proportion of what I've drafted in my career as a legislative drafter has really had only one audience, the auditor. Somebody wants to make clear that there was a proper legal justification for a payment. The auditor is not someone who cares much for fine writing, and plainly isn't too much interested in plain language, or at least what's plain to me. Possibly, if I'd had a degree in accountancy, what I put in on instructions to satisfy the auditor would flow like soft ice cream. So, here's where we're at. You're sitting down to write. You've got to produce something and produce it fast. We all know how the speed demands in drafting of all kinds have increased. Projects that I formerly would have thought could not be done in under 4 months are now 2-week projects. You sit back in your chair, you think through, do I need to worry about social workers here? No. Do I need to worry about a Ministry of Health lawyer who is going to be called on the carpet for this if it goes wrong? Yes. And right. As I say, simple-minded, yes. Effective, I hope so.
Hugh?
Well, I tend to come from a private practice background, so I'm looking at the question, who is actually going to read what I write? Very few people cuddle up with legal documents at night the way they would a murder mystery. So we need to look functionally at the people who are compelled to read. And if I do that, then plain language is not simply a way of purifying the verbal excrescences of the past. It's a way of communicating with that audience. Well, then who is the audience? And I think that, at least for the commercial document, the business law document, I can identify 4 audiences. There may be more, but I can identify at least these 4. First audience is the group of people who put the deal together. These are the initiators. They have a particular set of interests and a particular context for interpreting what we write. They're the people who have negotiated the deal and who want to see the key deal points put down on paper so that that can become a guide for the implementation. And that, in fact, points to our second group, the implementers. These are the people who are going to take what's been written and turn it into day-to-day practice. They're the people who keep the thing going and who need the guidance as to how to keep it going. And then we turn to the other group, the other 2 types of people who read our documents. And the one group are the advocates. These are the people who change their minds, the people who, when something occurs that's different, that changes, that's a bump in the road, that's an ambiguity, are going to re-argue what's going on. And finally, you have the arbitrators. These are the people, usually before whom the advocates argue, but not always, who will have to make some decision about how to deal with the ambiguities, the changes, and the differences. Now, do you find yourself in one of those groups? Do you identify strongly with one of those 4 groups? Because I would say that, in fact, lawyers play all 4 of those roles. That it's a mistake to think that clients are the initiators and the implementers, and that lawyers are the advocates and the arbitrators. But we often draft that way. We often draft as if only a lawyer could understand how to settle the dispute. The parties involved really are not competent to do that. And as I think of the audiences, and we'll come back to this point and talk about how to draft for change with plain language, I'd say there probably are several ways to be plain and clear, and that technical writing can be plain. It may not be comprehensible to everyone who picks up the document, but it can still be plain in the sense that it communicates effectively to its audience. Whether that audience be the initiators who are trying to set down the deal, the people who are trying to implement the deal, the people who do have to advocate when interests change, or the people who have to arbitrate between various competing positions. Back to you.
Actually, we're back to Ralph now to address our second question, which is, this is close to Phil's heart, does traditional legal language guarantee greater certainty than plain legal language?
Okay, and this leads nicely into one of my favorite rants, that there is a false dichotomy between certainty and plainness. If anybody in the world can show me how you can make yourself more certain by making yourself more hard to understand, well, I don't see how it can be done, because I have framed the question in such a way as to make it impossible, but I think I have framed the question correctly. The issue is getting the job done. What gets the job done? I think we all came to the conclusion many years ago that, hey, yes, we could get the job done using English instead of Latin. The fact that we were all taught a whole lot of Latin and like to throw it around in order to show, yes, we had gone to law school, didn't change the fact that the concepts, by and large, could be expressed in English. Now, having gotten that off my chest, we lead into the fact that we are lawyers, and some of our writing is essentially for other lawyers. So when we write in technical legal language, what we are using is not a barbarous tongue. What we are using is the proper technical language of our field. Plumbers speak to themselves using the appropriate terminology of plumbing. When I go back home to the farm, my wife can't understand what I'm talking about to my brother because we're using the proper terminology of farming. When we're working with documents that are of concern to other lawyers, there's no problem with using legal terminology. What we need to do is step back and say, who else is the audience? When I was young, articling for Doug Drinkwalder, a Crown attorney and director of the Ontario Police College, I spent a lot of time talking to cops. They knew various sections of the criminal code better than a heck of a lot of guys who were getting paid a lot of money to stand up in court and argue about those sections of the code. Can you frame your mind about what's plain to a police officer with a grade 12 education, some time at the police college, and 15 years of arresting people based on reading the code? If you, say, are a criminal law drafter for federal government, it's best if you can. But it's always a leap of imagination. In my paper, I go on, possibly at excessive length, although it's a short paper, about the fact that plain language has no commonly agreed on meaning that I can think of other than plain to me. The exact same document, read by two different people, even of the same education and social background, may get a response of, hey, that's fine, and oh my God. This is just a fact of life, that short of a world sometimes envisaged in science fiction where we can directly make brain connections and move our thoughts together, we're always taking a guess. I don't say worry about that. I say have it in the back of your mind when you're writing. Use your imagination and write to not the reader, but to the readers.
Hugh.
Phil, you put before us an interesting problem, and that was, how do we draft for change, knowing full well that we're going to experience change in the course of any agreement that goes on for more than 5 minutes? And this is a difficult problem. What changes? Well, people's interests change. I remember drafting an agreement, software contract, and the idea was that we'd put this thing together and we would stage the implementation. So phase 1 was the drafting of the formal specifications, phase 2 was the beginning of the drafting of the actual software. And I said to the client, when do you want to terminate this agreement? At what stage would it be reasonable to terminate? Well, we get past the functional specs. There's no question that we'll want the functional specs, and our first termination point will be at the first deliverable, when they show us the prototype. Excellent, I said, that's what we drafted into the contract. 2 weeks in, they say, we want to cancel the agreement. You don't want the functional specs? No, we don't want the whole thing. We found something better, we want to walk away from the whole deal. This was not drafted into the agreement. People change their minds. And then, of course, circumstances change. You go to a closing, or you're about to go to a closing, and you discover that the business that you are buying is suddenly located beside the new garbage dump. Something's happened that no one contemplated and was never part of the original risk allocation in the agreement. How do you handle that? People's interests change, circumstances change. You come to draft something, You think you've drafted it beautifully, and you discover that in the circumstances it's ambiguous. Something you thought was crystal clear, oops, how do you deal with that? All these things happen routinely. And I think we need to take an approach to that. First of all, look at your right hand. Is it the same right hand that you had 2 weeks ago? Or is it a different right hand? Has it come in from somewhere else? I think most of us would say, well, it's obviously it's the same right hand, still attached to my wrist in all ways. And yet if you think seriously about it, each of the little cells is gradually being replaced. And your right hand in many ways is adaptive. That is, if you squeeze balls over the course of several weeks, the muscles in your hand will become stronger. So that although your right hand stays the same, it actually changes. And that in some ways is what we hope to do with a legal agreement. Create a legal agreement that stays the same and yet adapts and changes. And so inserting words like it's reasonable or it's materially the same are not in fact creating uncertainty in the agreement. They're giving you the space to let the agreement adapt. They're giving you the space to let the understanding that the initiators came to work itself out in the circumstances. And that, I think, in some senses, is what real plain language could mean. Whether it actually does or not in the circumstances, I'm not sure, but it could. And that is that you draft for the implementer with the idea that that audience will have to deal with change. And so you draft into the document some sense of how to implement the understanding that the initiators came up with in changed circumstances. And you may want to keep the advocate at bay. Take the tiger and put it in a cage. Often we draft agreements for the tiger, for the advocate in us, for the person who's going to say, rip up the deal. Let me at it. I'll show you how we can win this big. And I think sometimes instead of trying to win it big, you might want to say, how can we adapt it like the right hand? And I think that sense of plain language, truly communicating what the deal was supposed to do, rather than trying to nail it down, is what to me plain language really means, really communicating to the audience.
Phil, and I remind you, Phil, I'm setting the timer. Knowing this is one of your favorite topics.
Well, it's a favorite topic, but so much of it's been covered so well by the previous two speakers. I'm going to simply use some illustrations, I think, of the differences. Let me say that I thoroughly agree with the notion that we can be considerably more certain using general language often than using specific language. One of my favorite examples of that is to point out that we in fact do not list all of the many ways in which one might kill a person in our criminal code prohibitions in any country on murder. We rely on the rather general concept of doing somebody in with felonious intent, and leave it to the courts to in fact say, well, yes, when you stab the person, that's it, and when you bring about the result, no matter how you bring about the result. Think of what it would look like if we used a specific. First of all, it would be it might be an interesting long list. But think of the uncertainty the minute somebody did somebody in by a novel method. We'd suddenly say, well, oh, wait a minute, the legislature didn't actually forbid this method of doing in a person, so maybe it was intended to be excluded. And we'd have to scratch our heads at least for a few minutes and wonder about legislative intent before stumbling on a statutory interpretation rule that would let us include that. The general can sometimes be considerably more certain than a long shopping list of the specific. The long shopping list of the specific, I think, is exactly Hugh's document written with the advocate in mind, to preserve it from being torn apart by the advocate. I want also to say that we need, when we're looking at these kinds of things, to be careful, though, about the kind of analysis we bring when we're criticizing traditional legal drafting. It seems to me that it is not good enough to simply say, here's a textual analysis of what's wrong. And for this, let me rely on an article published by my good friend, an American professor, Joseph Kimball, who wrote in 1999 on the then very topical subject of presidential impeachment orders. And in fact, he quotes the entire impeachment order that ended the trial of President Clinton, including, well, this is the order. The Senate, having tried William Jefferson Clinton, President of the United States, upon 2 articles of impeachment exhibited against him by the House of Representatives, and 2/3 of the senators present not having found him guilty of the charges contained therein, it is therefore ordered and adjudged that the said William Jefferson Clinton be and he is hereby acquitted of the charges in this said article. And Joe goes on to a very long analysis from a strictly textual, plain language critique of what all is wrong with this order, and proposes to get rid of the traditional language, which the infinitely more certain and correct, he believes, statement that the Senate has tried William Jefferson Clinton, President of the United States, on 2 articles of impeachment brought by the House of Representatives. Fewer than 2/3 of the senators present have found him guilty of those orders. Therefore, it is ordered that President Clinton be acquitted. Now, Joe says it's shorter and it's stripped away all the traditional trappings of language and everything else. And Joe was somewhat mortified when I wrote back to him and said, but Joe, who's going to acquit President Clinton? Because the Senate has ordered that he be acquitted. Who is the order directed to? Who's giving effect to the order? Who's going to do the acquitting? In fact, the answer is that the 2/3 of the senators who voted to acquit him have already done the acquitting. Joe's issue was to say, oh, well, a judge and order are doublets. They're the same thing. And I said, Joe, had we approached this instead of from a simply formal critique of the language and approached it from a functional critique of the language, you could have come to the heart of the problem here. The heart of the problem is that we're ordering something that's already been done. What's the point of that? Why do we write things like that? I think we write things like that because we get caught up in the formal language and we lose sight of the objective of what it is we're actually trying to achieve. And so in his case, while I say his example is infinitely more pleasurable to my ear, and I think more modern, it's no better in a strictly legal sense. And a different kind of analysis could have led to a better legal statement, a legal statement that was more accurate in the context of the law as it was. I want to put up on the overhead a couple of other examples. This, in fact, you won't be able to read it, and I'm not going to read the whole thing to you, but it is an example of a very traditional approach to statutory drafting. And it, as you can see, is very dense. It has got paragraph sculpting, but it's all one sentence all the way down from, does my finger show? Yes, from this point to here is one sentence with subclauses and embedded subclauses and so on. And even if you did read it, Well, let me just simply say this. I read it 10 times before I understood what I thought was the function. And I, in fact, only really got it clear because I had the benefit of the second version that another lawyer had developed. Now, the second version tells me that what's going on here, first of all, has some definitions that are broken out, and the rule is set out in fact, subclause 2, and begins this way. I'll read it because you probably can't see it. An employee's hourly rate is calculated by dividing that employee's basic wage by the number of ordinary hours that employee works in a day, if the employee is paid on a daily basis, or a week, if the employee is paid at intervals of a week or more. And then sub 3, an employee's daily rate is calculated by multiplying the hourly rate by the number of hours ordinarily worked in a day, or dividing that employee's weekly basic wage, and so it goes. And you still say, scratch your head and say, huh? After a lot of analysis, the third version begins with the same topic called, no, in fact, the first topic was called, the original topic was called calculation of remuneration. The second was calculation of basic wages, and the third is calculation of various wage rates. Already you're seeing that, in fact, the time has been taken to figure out what exactly is the purpose of this rule, and the purpose of the rule is now stated. You know what? People's wages are sometimes calculated one way, but they have to be converted. And then you have the opening words, the provisions of this section apply when for any purpose of this act it's necessary to determine the applicable hourly, daily, weekly, or monthly rate of pay for an employee paid on a different basis. Can I have 2 minutes? 1 minute.
You
The
have 1 minute.
last slide I'll put up, because this is in fact where I think we can make a difference. I can't remember if it was Ralph or Hugh who said, imagine.
I was gonna fix this while you talk.
Imagine, never stop imagining what you can do. Okay, and I appreciate this does not show up particularly well, but in this case, the imagination was take all the words that we just get lost in and set them out as a table. People are paid on an hourly basis, a daily basis, a weekly basis, a bi-weekly basis, or a monthly basis. And sometimes you need to do the conversion. So down one side, list the ways people are paid. Across the top, list the ways you want to convert their wages to. And in the cells that are created in that table, put the formula. And when you need to do one of these exercises, find the cell you need, apply the formula. That's all. That's the rule. Now that, it seems to me, is applying not just the techniques of linguistic analysis, but a careful functional analysis. What is the function of the rule I'm trying to make? Now what's the best way to achieve that function? What's the best way to let readers achieve that function when they have to?
Thank you. I'm going to talk, now I'll set the timer on myself, for just a few minutes on what I call plain language as organizational clarity. And that couldn't have been a better introduction to what I think of as organizational clarity. The table that Phil put up. And I'm often in the workshops I run with lawyers trying to persuade them to present information in a chart format, because often they're doing a before and after analysis, and it's just more helpful, it's more readable, it's more usable for the writer. But I'm not going to review the paper. I'm just going to give you 3 thoughts about the background to why I wanted to write the paper, which is a set of guidelines for what I call organizational clarity. The first reason is the drafting literature is actually not very accessible. Unlike the literature on legal research and writing, there are about somewhere between 15 and 20 textbooks on legal research and writing, and a number of really good books. There are relatively few good sources on legal drafting. And in fact, I can think of maybe 3 teaching texts, all of which are US. So that's one reason I wanted to give everyone a few guidelines that might be helpful. The second reason is that in the workshops I teach, I often find that lawyers are struggling with organization. And while they're, terrific at putting sentences together, and I'm finding that more and more the more I teach, they're actually less terrific at thinking through a logical and helpful organization for the reader. So that's the second reason I wanted to put that in. And I'm hoping that this paper functions for you on two levels. The first is the technical level. We need to have a set of technical skills in order to draft. And some of it is understanding grammar and being able to put a sentence together and understanding punctuation, those sorts of technical skills. I didn't get into those, but that's what I'm talking about when I'm thinking of technical skills. The other is that organization functions at a conceptual level. And what we are very often doing as drafters is grouping like concepts together and then excluding concepts that are unlike. And that goes back to Paul's comment about drafting definitions. Definitions are all about creating classes or categories, and what's in the category and what's outside the category. So organization functions to help you think through the concepts, the drafting concepts. And it functions at three levels: the level of the document, so large-scale organization; the level of the paragraph or the provision, think of it in those terms; and the level of the sentence. And so that's why I've set out my little set of guidelines, which are intended to be flexible and consistent with this panel, for you as well as a background for the work to be done in the workshops this afternoon. So those are my thoughts on organizational clarity in a couple of minutes. I don't know if others have thoughts on the benefits of plain language or other thoughts on organization. Anybody wants to chime in before?
I will chime in and simply say this: organization is enormously important, very critical to people being able to find information, and finding information is extraordinarily critical. I mean, we've done research on this where it's remarkable the consistency with which people lose patience for finding information, and when they lose patience, first of all, how quickly their will to continue searching falls away, and more to the point, how quickly their accuracy of result falls away. So there is a direct link between finding the right thing you're looking for and getting the answer, the legal answer right, and finding the right thing you're looking for is very much a function of how well organized the material is in the first place.
Thanks. Well, Phil's going to wrap up the panel by talking to us for a few minutes about judges and whether they like plain language.
Yeah, I'm not sure why I'm doing this. I've never been a judge. I began my law career, though, working as a clerk in the Manitoba Court of Appeal, and had the remarkable privilege of working with judges and, in fact, seeing behind the veil that most lawyers, I presume, never penetrate, which is how do judges behave in chambers? What do they talk about? What do they do? And I'm here to tell you that with their coffee in the morning, they're just as likely to read the sports pages as anyone else. So do they like plain language? Yes. How would they define plain language? Much the same as all of the struggle that we talk about here, I think. And do they indicate a preference for plain language? Yes. When asked and surveyed and shown two documents, one of them ostensibly plain and one not, invariably judges will answer surveys like that, indicating a preference for the so-called plain language version. Let me make this first observation. Preference tests are just that. The results don't tell you anything about the documents. They tell you that someone prefers it. And that's as useful as a preference test is, and I wouldn't hold out a preference test as proof of much having to do with the benefits of the language it exhibits. But I think there's enough statement from judges about things that they found unplain and difficult to read that we can certainly take a direction from that. We have one. I'm not going to put it up because putting these things up doesn't work very well. And in the process of, here it is, we have a marvelous example from another friend, this time in Australia, who's, this is from a case called Ravenseft Properties and Davston Holdings, 1979 English case. Clause 5.6 of the lease in question read, "The tenant shall, where, when, and so often as occasion requires, well and sufficiently, repair, renew, rebuild, uphold, support, sustain, maintain, pave, purge, scour, cleanse, glaze, empty, amend, and keep the premises and every part thereof, and all floors, walls, columns, roofs, canopies, lifts, and escalators, shafts, stairways, fences, pavements, forecourts, drains, sewers, ducts, flues, conduits, wires, cables, gutters, soil, and other pipes, tanks, cisterns, pumps, and other water and sanitary apparatus," God knows what that could have been, "thereon, with all needful and necessary amendments whatsoever." Mr. Justice Forbes, I have already mentioned the plethora of words used to describe the obligations of the tenant in Clause 5.6. The view I have formed is, of course, relative to the use of the word repair, and that by itself seems to me to be sufficient to render the defendants, that is to say the tenants, liable for the whole cost of the remedial work, which is a very sort of polite and refined way Justice Forbes had of saying one word would have done. And the very fact that he thought to write 2 sentences on the subject, I would interpret as being a strong indication of his preference for at least that would have included the one word that he thought might have done. Let me say this: the former Chief Parliamentary Counsel in England, Sir Edward Caldwell, in a presentation on the subject of plain language, said, "The problem is everybody would like the things we write to be more enjoyable to read. And in that sense, judge our writing to be not plain." He said, "And let me tell you the truth, statutes are boring." This from the man who oversaw the creation of statutes for 10 years in the United Kingdom. But he said there's a reason they're boring. And I must confess, until he commented on this, I'd never really thought about it this way. He said they're boring because they have to be boring. They have to be devoid of color. They have to be devoid of action. He said, what are we supposed to do? Start embellishing the statute book with colorful little asides that will in fact shift meaning? We can't. So what do the judges prefer? They prefer it were, as we all do, more readable. Since it can't be necessarily more readable, what we must do is make it as simple, it seems to me, as we can.
Thanks, Phil. And just to wrap up, to come back to the question I posed, a problem I posed at the outset about advanced drafting as solving complex problems. What we've done in the panel today, I think, is look at complex problems in the private sector, the public sector, and seeing the intersections between the problem solving in plain language as thinking about the audience, multiple audiences, thinking about changes in circumstances, and looking really at a functional textual analysis, which is what we have to do as we analyze and draft. So thanks to all.
To take a 10-minute break so that we can be back on track and come back in the room for 10-2. Thank you.